Welcome to the SODA ASA Symposium. It's Privacy Week, it's Privacy Day, at least for us today. And we're going to give our guests a few moments to join the webinar. We had close to 300 people sign up, or 250 or something. I forgot the latest numbers. It's private. And while I'm chatting here, we're giving them a chance to all log in. And you'll hear back from me in a minute. All right, welcome everybody. Welcome to the SODA ASA Symposium in celebration of Privacy Week. This webinar, as you might have seen, is being recorded and will be made available on the SODA website next week. We'll have time for questions at the end of the presentation. So for those of you who are out of practice with Zoom or hang out on other platforms, right in the middle here, there is a Q&A feature that you can use anytime during the symposium and write in your questions. And then our moderator, Jay June, will issue those questions to the participants and they can answer it as time allows. If you like the opportunity to ask your question live, you can make a note of that and then we can unmute you during the Q&A portion. So with that, I'm delighted to introduce you to our moderator for the event, Jae-Jun Lee. Jae-Jun will be hosting this for the rest of today. He is a CQR fellow at the National Conference on Citizenship. And Jae-Jun, the floor is yours.
Great. Thank you. First of all, thank you to SODA and for Frauke and Jody for hosting the webinar. Yeah, my name is Jay June. I will be moderating today's event. I am, as Frauke mentioned, a fellow at the National Conference on Citizenship. And it's my pleasure to introduce the speakers for today. So starting with Dr. Sally-Ann Keller. Dr. Sally-Ann Keller is the Chief Scientist and Associate Director of the U.S. Census Bureau's Research and Methodology Directorate. She also holds an endowed distinguished professorship and faculty appointments at the University of Virginia. And as chief scientist, she leads the Research and Methodology Directorate's research centers, each devoted to domains of investigation important to the future of social and economic statistics. She is a nationally recognized research scientist whose areas of expertise are social and decision informatics, statistical underpinnings of data science, and data access and confidentiality. She is an elected member of the U.S. National Academy of Engineering, and she's a fellow of the American Association for the Advancement of Science, an elected member of the International Statistics Institute, and a fellow and past president of the American Statistical Association. Next, Michael Hawes. Michael Hawes is the U.S. Census Bureau's senior survey statistician for scientific communication. In this role, he's responsible for research and development in the area of scientific communication regarding the agency's initiatives and issues relating to access, management, quality, and the confidentiality of Census Bureau data and statistical products. He also advises agency senior leadership on improving technical communication to scientific journals, government officials, agency partnerships, media, data users, and other stakeholders. Michael is a member of the Federal Committee on Statistical Methodology, or FCSM, and serves as a vice chair of the FCSM-sponsored Federal Disclosure Review Officer Council. He's a senior fellow of the Partnership for Public Services, Excellence in Government Program, and he also serves as an appointed member and chair of the American Statistical Association's Privacy and Confidentiality Committee. And finally, we have Alexandra Wood. Alexandra Wood is a visiting assistant professor of artificial intelligence, policy, and society in the Department of Political Science at Purdue University. Additionally, she serves as an adjunct faculty member at Brandeis University and as an affiliate at the Berkman Klein Center for Internet and Society at Harvard University. Her research seeks to advance the co-design of law and computer science for the governance of emerging technologies and socio-technical systems. She is a co-recipient of the 2019 Casper Bowden Award for Outstanding Research in Privacy Enhancing Technologies for work introducing a framework for bridging computer science and legal approaches to privacy. So with those introductions, I invite Alexandra to turn off her camera and for Michael and Sally to share your PowerPoint presentations.
Great. Thank you, Jay June. Let me just share my screen here. All right. Can you confirm you can see it?
Looks great.
Okay, wonderful. Well, thank you so much, and happy Privacy Day, everyone. We're very excited to be able to talk a little with you and discuss with you at the end about kind of the evolution and interpretation of the phrase statistical purposes, and particularly the oft recurring phrase for statistical purposes only. Before I start, I want to thank our current and former colleagues at the Census Bureau that have contributed to this project, especially John Elting, Paul Mark, and Danielle Neiman. And also, I want to state that any opinions or viewpoints that are expressed in this presentation are entirely our own and not the opinions or viewpoints of the U.S. Census Bureau. So statistical agencies often reassure the individuals and establishments from and about whom they collect information that their information will only be used for statistical purposes. Here you can see three examples of the use of this term by the Census Bureau, the National Center for Health Statistics, and the Bureau of Labor Statistics. But the term is fairly ubiquitous across the entire federal statistical system. Now, cognitive testing informs us that the term is poorly understood by the average data subject. The context of its use might imply a focus on privacy, confidentiality, and protections against the information being used to the harm of the individual. If you ask a statistical agency employee, they would certainly agree with that, and would probably also extend the phrase's interpretation to include some focus on public or societal benefit as well. But why would any of this actually be the case? Statistics, as a scientific discipline, spans a literal A to Z of applications, from astrophysics to zoology. But there's nothing inherent to statistics as a science that requires confidentiality or protection from harm. In fact, statistical methods are often used for things like targeted advertising, determination of program eligibility or benefits, or law enforcement purposes. So if statistics is so broad as a discipline, why does our use of the phrase for statistical purposes only seem to preclude these broader uses of the information? And what do we actually mean when we say it? So to answer this question, it's helpful to take a little trip through history. Article 1, Section 2 of the US Constitution mandates an enumeration of the population, a census, to be conducted every 10 years in such manner as Congress shall by law direct. The first such census in 1790 was conducted by the newly established US Marshals and their assistants. And Congress required the Marshals to post the information they collected, including individuals' names, in two public places within each enumerated area, to allow the public to review and correct the information before it was officially submitted. Clearly, confidentiality of the census responses was not a concern, nor was it really one for most of the following century, as the marshals continued conducting the census until they were replaced by specially trained enumerators for the 1880 census. In fact, confidentiality, protection from harm, and exclusively public benefit didn't really become associated with the census until President Taft's proclamation for the 1910 census, which proclaimed the census to be, quote, of the utmost importance to the interests of all people in the United States. The proclamation also affirmed, in what is starting to foreshadow the phrase that we're familiar with, that the census's sole purpose was to secure general statistical information. And it further promised that the census has nothing to do with taxation, with army or jury service, with the compulsion of school attendance, with the regulation of immigration, or with the enforcement of any national, state, or local law or ordinance. Nor can any person be harmed in any way by furnishing the information required. Now, in spite of President Taft's pronouncement that an individual's identifiable census information would not be used against them, the 1910s and 20s saw frequent usage of census data for legal cases relating to draft evasion, as well as immigration and deportation proceedings. The Census Bureau even compiled lists of respondent names by literacy status for state and local officials in support of their literacy campaigns. This laissez-faire attitude about the use of identifiable information soon ended, at least temporarily, with the passage of the 1929 Census Act, which provides what may be the first extant usage of our phrase of interest, specifying that the information furnished under the provisions of this act shall be used only for the statistical purposes for which it is supplied. No publication shall be made whereby the data furnished by any particular establishment or individual can be identified, nor shall the director of the census permit anyone other than the sworn employees of the census office to examine the individual reports. Now, the strength and specificity of the association of statistical purposes with the confidentiality of respondent information here is remarkably similar to today's interpretation of the term. Unfortunately, these new protections were relatively short-lived, and the exigencies of war first strained and then fully shattered this emerging idea that the statistical purposes for which these data are collected preclude their use in a manner that could harm the individual data subjects. In early 1942, the Census Bureau assigned a statistician to assist the war agencies to provide on-demand census tract and block-level aggregate tabulations of Japanese Americans living in California for use in identifying where to focus efforts for rounding up these individuals as part of the internment effort. While it does not appear that any identifiable information from the census was directly shared with the war agencies or law enforcement as part of this effort, the significant group harm resulting from this use of the data is clearly evident. But even this line in the sand was quickly abandoned when the Second War Powers Act in 1943 formally repealed the confidentiality of census data, thereby allowing federal agencies to request copies of individual census records. Most notable among the subsequent disclosures of identifiable 1940 census data was a list provided by the Census Bureau to the U.S. Secret Service containing the names, addresses, occupations, and citizenship status of all Japanese Americans residing in the Washington, D.C. metropolitan area. By the late 1940s, most of the Second War Powers Act was repealed, returning the confidentiality guarantee of the decennial census. These protections were then further strengthened with the 1954 codification of Title 13 into the United States Code. In this codification, we again see the phrase statistical purposes as part of these protections, limiting the use of identifiable census data for any purpose other than the statistical purposes for which it is supplied. Though the phrase statistical purposes did remain undefined in the statute. Now, fast forward to the 1970s, and growing public concern about privacy and the misuse of government information led to the passage of the Privacy Act of 1974 and the subsequent formation of the Privacy Protection Study Commission. The Commission's final report introduced the concept and importance of the functional separation of federal statistical activities from federal administrative or enforcement actions. And in establishing this concept, the Commission's report uses the term research or statistical purpose. Specifically, their definition of functional separation entails separating the use of information about an individual for a research or statistical purpose from its use in arriving at an administrative or other decision about that individual. Now, as we shall see, this differentiation of statistical from administrative purposes becomes central to subsequent interpretation and codification of the phrase a couple decades later. By the 1990s, declining trust in government and growing concerns about data privacy in the nascent internet age prompted the chief statistician of the United States at the Office of Management and Budget to issue an order enhancing the purpose specification and limitations of federal statistical collections. This order at last provided a formal federal definition of statistical purpose as, quote, the description, estimation, or analysis by the federal government of information concerning persons, the economy, society, or the natural environment, or relative groups or components thereof, without regard to the identities of specific persons, and excludes many other activities or functions for which information is used in identifiable form, such as determining whether a person is eligible for a license, privilege, right, grant, or benefit, or whether a person's conduct was or is in accordance with law. Later, the 2002 passage of CIPSEA, the Confidential Information Protection and Statistical Efficiency Act, put this language into statute nearly verbatim via the Act's definitions of statistical purpose and non-statistical purpose. This statutory definition was later reaffirmed unchanged when CIPSEA was amended with the passage of the Foundations for Evidence-Based Policymaking Act of 2018. At the same time, this period also saw the creation of an information quality framework that served to enhance how agencies and the broader public think about the statistics that these agencies produce. The Information Quality Act of 2001 and OMB's implementation guidance in 2002 required agencies to establish and follow data quality standards. The federal statistical system then extended this framework through the promulgation of Statistical Policy Directive Number 1 in 2014, which defined these requirements in the context of the fundamental responsibilities of statistical agencies to produce and disseminate relevant and timely information, to conduct credible, accurate, and objective statistical activities, and to protect the trust of information providers by ensuring confidentiality and exclusive statistical use of their responses. Responsibilities that were formally codified as part of the Evidence Act in 2018, associating all of these responsibilities with the broader concept of statistical purposes. Now, through the evolution of the term statistical purposes over the 109 years between President Taft's 1910 proclamation and President Trump's signature of the Evidence Act in 2019, we see clear commonality relating to confidentiality, constrained use, and the prevention of harm to the individual. CIPSEA's definition of statistical and non-statistical purpose together convey a strong notion of confidentiality along with a strong commitment not to use identifiable information about individuals in a manner that can harm those individuals, giving us two dimensions of protections: the access or confidentiality dimension with limits on who can access the identifiable information, and the use dimension, which ensures that the information is used appropriately and not in a manner that would directly harm the individual. These two dimensions baked into the broader interpretation of statistical purposes are intended to work in tandem to help reassure data subjects that they will not be adversely impacted by participating in a survey, that the data can only be used to produce statistics about groups, and that the information can only be accessed by the individuals who will be producing those statistics. Now, I'll turn things over to Sally to discuss how we might think about and enhance this concept of statistical purpose as the federal statistical system evolves over the coming years. Sally? And you're on mute, Sally.
Thank you, Michael, and welcome everybody to Privacy Day. And I also echo Michael's thanks to our collaborators in thinking through some of these issues. Next slide, please. So we're in sort of a whole new ball game today when it comes to building statistical products within statistical agencies. And I would first argue that we've been a little nonchalant about this term and this issue of preserving statistical purposes historically. It's written in the different acts and legislation and things that Michael has just described. It was put there for a really good reason. But I think we've been sort of, pedaling along, doing our work, building our products, thinking about confidentiality, frequently talking about privacy and all the issues that go around with it, the privacy enhancing technologies, but rarely do we see people who are arguing for increasing privacy or arguing for the importance of privacy for trust of our respondents, rarely, if ever, talk about statistical purposes. And statistical purposes is so important because it is what draws this hard line in the sand between the use of the data that we integrate into building statistical products from administrative uses of that data. So it's so important. And as Michael said, it goes in tandem with everything we've just been talking about. But I think we need to elevate the importance of this fact that is helping us protect the use of the data that we collect to build statistical products. Today, with the increasing interest and the increasing activity around acquiring administrative data, whether it's from the public sector or the private sector, to help support the development of our products. And the fact that within our agencies, at least within the Census Bureau in particular, we possibly have the best data linkage infrastructure of linking all of these administrative data records together than anyone. There's a lot of great work going on record linkage for sure, but in terms of a system implemented at scale that can link massive amounts of records about people or places or organizations together, is pretty impressive. So we have this beautiful set of data to build statistical products from. But it also means that it can be quite unnerving as people learn more and more about the fact that administrative records are coming into our agencies to help build quality statistics that we will protect and only use for statistical purposes. And so as we've been talking to internal and external stakeholders, we like to remind them that there's sort of three, well, probably more than three, but I'll give you three really important touch points. Number one, the data that comes into our organizations are coming in through data use agreements, which is an agreement between, in our case, the Census Bureau and the entity providing the data. In that data use agreement, there's specific information about how these data can be used, and these uses that get described are all for statistical purposes, and that how they expect the protection of the data and statistics coming out from that data. So that's built into the data use agreements. This is built into Title 13 for us, which includes this bright line in the sand between statistical purposes and administrative purposes. And that's all really great, and it's something that we can talk about and ensure that we adhere to, but nonetheless, there's clearly growing concern externally and internally about our ability to hold true to these tenets. So we can improve our products on the one hand. On the other hand, we have to work really hard to continue to maintain the public trust. Next slide, please. So there's actually an executive order that you may or may not be aware of that has come out in the past year that helps us. So this executive order, which is called Restoring Gold Standard Science, is really aimed at ensuring that research that is supported by federal funding, so that's everything we do in the Bureau, because we have this continuous life cycle between research, product development, product dissemination, feeding back into research to improve that cycle, that there is the expectation that we be transparent in what we do, that we be rigorous and impactful in the choices that we make about the science, and that we report things in a very informed, credible, reliable, and impartial way. And so let me talk just a little bit more about that, because this is for me as the chief scientist at the Census Bureau, this is a very exciting executive order. It actually amplifies things that I think we have always been doing, but it puts it really dead center, in the public eye, and helps us in protecting our work and protecting what we do. Next slide, please. So one question that you might have is, where does that fit into this whole constellation of things that Michael just talked about? So the Information Act, which directed OMB and federal agencies to issue guidelines on data quality, that was the 2001. When this executive order came out, it was differentiating the use of data and the generation of science, sort of the use of science and the generation of science. So for certain agencies, perhaps a regulatory agency, the generation of the science might be building the model that's going to be used to measure whether you're in compliance with different guidance. And the use of that model would be what the Information Act would really be applying to. However, when the Information Act came out, and as OMB started to issue guidelines, there were special guidelines issued to the statistical community, to the statistical agencies. And these guidelines that were issued to us commingled use and generation of our science. And we've used this fact when we have been putting together our plans for how do we respond to this executive order, to make the point that we can't separate use and generation of science. It's all intertwined by design, and we've gotten, great traction on that. And our plans have been accepted around that premise. The last box is that following those statistical policy directives, the Census Bureau and other agencies developed quality standards. And so now today, we have this executive order, and it's directing OSTP to issue guidance, which, they have done. And in their memo, they're asking that we adhere to these tenets of gold standard science. And the next slide will demonstrate clearly that these tenets, you're going to love them because they really reinforce our professional codes and standards. So there's 9 of them. One is about reproducibility. This has been something we have been talking about for a long time. One is about skeptical findings and assumption. We're always, taking different approaches and clearly discussing our findings and our assumptions based on those. It needs to be without conflict of interest and commitment, and that's something that's been really pushed through NIH and NSF in the last 8 years. A lot of concerns around that, and we've really beefed up awareness of researchers, of agencies, of leadership around that. It needs to have unbiased peer review. Well, how smart is that? I mean, again, something we've been doing for a long time, but now we really can amplify the fact that, look, we are going to be doing unbiased peer review. We will not release results without that. We need to communicate the error and uncertainty in the statistics that we produce. And this is one of my favorite tenets, as Michael knows. And I think as statistical agencies, we do not do enough around this. We're not producing and developing all of the uncertainty measures to go with all of the statistics that we produce in ways that we should. And I think we really need to focus on that. Yes, we produce MOEs and MOUs from sample surveys. We argue that, well, nobody uses them. Why should I produce them? Well, we should produce them because we need to get people to start using them, and we should be producing these things around all of our statistics. Now, the next one is structured for falsibility of assumptions. And this goes right along with the accepting of negative results or positive outcomes. And so again, whereas that the tenet about falsibility of hypotheses may have been more focused on more basic science lab work than social and behavioral type of areas, but it applies to us as well. And so we need to focus on that. And I think we have a real challenge in how do we start reporting negative results on a routine basis? What are the vehicles and ways that we can do that? How do we prevent people from, kind of going down a path that that's already been demonstrated it hasn't worked? That gets embedded in, an introductory paragraph of papers sometimes, but we really need to think about that. And there's not a lot of value to the researchers right now to do that. It should be collaborative and interdisciplinary. That's the hallmark of statistics and social and behavioral sciences for a very long time. And really importantly, it needs to be transparent. So all of these tenets, coupled with, for statistical purposes of the products that we develop, create an incredibly powerful message and opportunity for us to do the best science that we can. It is completely consistent with the scientific rigor that we have strived for a long time. And I should also make the point that our professional codes of practice are central to this, is that we need to be adhering to those, of which I think we're all on board with, but it really brings to the forefront the importance of having professional codes of practice. And also this internal and external peer review is a really important piece that not all administrations would appreciate what that means. So we're excited about this. And I'm also really excited that we're starting to revisit the implication of for statistical purposes. I think it's, perhaps that somewhat hidden nugget over the years that will protect us the most. I'm done. You're muted.
Turning
Sorry,
things back
Michael.
to you, Jay-June.
Awesome, great. Well, thank you very much. Thank you for a great presentation. I will ask, Alexandra to come on camera, Michael and Sally to go off camera, and then you can go ahead and share your screen.
Thank you, Jay-June, and the organizers for hosting this fantastic event. And thank you, Sally and Michael, for providing an overview of statistical purpose from a statistical agency perspective. I'd like to zoom out a bit and look at statistical purpose definitions more broadly, to understand their bounds as they exist today, how they're often interpreted, and how we could imagine strengthening those interpretations in the future. This work stems from research initiated in 2016 as part of a cooperative agreement between the US Census Bureau, Georgetown University, Harvard University, and Boston University. The goal of this research was to better understand the Census Bureau's confidentiality mandate, and statistical purpose is a critical component, but it's received relatively little attention compared to other related concepts like identifiability. Statistical purpose operates as a specific case of purpose limitation. It defines the boundaries of what kinds of data processing are permitted and often triggers regulatory obligations that differ from those governing other uses of personal data. Yet despite its central role, there's no settled and consistent definition of what's a statistical purpose. And in practice, organizations fill in that gap with their own interpretations and assumptions, which can vary considerably. I argue that clarifying the meaning of statistical purpose will be essential to preserving statistical integrity, sustaining public trust, and ensuring that data protection laws function as they were intended, particularly as statistical and machine learning analyses become increasingly pervasive across an expanding range of applications throughout society. And these questions are not purely theoretical or motivated by real-world controversies that have highlighted challenges around the boundaries of statistical confidentiality, and I'll use these cases to ground this discussion. In particular, I'll talk about the use of data from the 1940 census in support of the forced evacuation and internment of people of Japanese ancestry during World War II, the post-9/11 special tabulation of data from the 2000 census detailing the locations of people of Arab ancestry for the Department of Homeland Security, and debates about the relationship between statistical inference and confidentiality that were brought to the fore with the implementation of differential privacy in the disclosure avoidance system for the 2020 census. These cases are all very different from one another, but they each illustrate critical problems associated with defining statistical confidentiality. My talk will proceed in 4 parts. I'll begin with an historical overview of the origins and functions of statistical purpose limitations. Then I'll highlight different aspects of the many interpretations of statistical purpose. And in light of the limitations of the definitions on their own, I'll explore how external authorities could serve as guides to interpreting or reinterpreting this concept. And I'll conclude with some ideas regarding practical interventions and the implications for policy and practice. So with that in mind as background, I'll briefly introduce the origins and functions of statistical purpose. Margot Anderson and William Seltzer and their scholarship have traced the historical evolution of statistical confidentiality and have identified its roots in the term statistics, which was originally defined as the analysis of data about the state. Early statists, as they were called, saw the potential of data collected and used for administrative purposes as a basis for generating new knowledge. They developed the first techniques for statistical analysis, or a collection of approaches designed to draw collective insights from aggregates stripped of identifiers. Over time, statists pushed to establish a body of practices for the government's collection of data for statistical purposes only, and for the use of administrative data for statistical purposes, laying the groundwork for how we think about statistical use today. Anderson and Seltzer find that from the beginning, statisticians have recognized the critical importance of maintaining a strict separation between administrative and statistical data, but this was not understood beyond the statistical community. There were many administrative requests for statistical data, beginning with requests for individual business records during President Theodore Roosevelt's trust-busting investigations. The statistical agencies pushed back against these requests, and the statistical community worked to develop ethical and confidentiality protections in response. And these efforts led to the first statutory confidentiality mandate for establishments in the 13th Census Act in 1909. But administrative requests for individual level census information were persistent. They sometimes met resistance. For example, requests came in from the Justice Department for citizenship information in deportation cases, from draft enforcement officials, which ultimately succeeded and even inspired a failed plan to redesign the 1920 census for selective service registration. And there were requests from the Internal Revenue Bureau for child labor-related tax records, which were also successful. In 1929, the 15th Census Act extended confidentiality protections to individuals and added a critical provision: information collected by the Census Bureau could not be used to the detriment of respondents. And notably, administrative requests for census data have increased during periods of crisis. During World War II, the Census Bureau initially resisted requests for census data, citing statutory confidentiality protections and the norms of statistics. And this resistance prompted extensive legislative and administrative efforts to curtail the protections in place. These were repeatedly blocked by the Census Bureau and by the Attorney General. That changed with the enactment of the Second War Powers Act, which suspended census confidentiality protections and allowed access to census records for use in connection with the conduct of the war until its repeal in 1947. And in practice, this enabled the Army to obtain counts, as well as, in some cases, names and addresses of people of Japanese ancestry, to carry out forced evacuation and internment. And while evidence later emerged that the Census Bureau shared some names and addresses of people of Japanese ancestry with the War Department, the sharing of counts alone was also controversial. As Raymond Okamura argued in 1981, even if names and addresses had not been disclosed, the disclosure of sufficiently detailed census information to enable the identification, location, and internment of a targeted population calls into question whether such use can plausibly be described as the statistical purpose for which individuals provided their race or ancestry in response to the 1940 census. And in the absence of a clear definition, statistical purpose risks becoming a justification for uses that were inconsistent with the purposes for which the data were collected. In 1976, Congress amended Title 13 to add further protection of privacy by prohibiting the disclosure of information reported by or on behalf of any respondent, restricting the scope of permissible recipients of raw census data to respondents, their heirs, or authorized agents, not governors of states, territories, and courts of record, and prohibiting the furnishing of statistical information which would disclose information reported by or on behalf of any respondent. And Title 13's confidentiality mandate can then be understood as an overlapping set of constraints, prohibits publications whereby a particular establishment or individual can be identified, disclosure of information reported by or about any respondent, use of census data for any purpose other than the statistical purposes for which it was applied, or any use to the detriment of the individual to whom the information relates. A permissible use or disclosure of census data by the Census Bureau must meet all of these requirements, as the Supreme Court held in Baldridge v. Shapiro. And the Baldridge case also shed light on the meaning of Title 13 statistical purpose limitations specifically. In this case, Denver officials had argued that they should receive vacancy information from the Census Bureau's master address list so that they could use it for the statistical purpose of verifying the accuracy of the 1980 census counts. But the Supreme Court rejected this argument. They held that Title 13 permits use of census data only for the specific statutory statistical purposes for which it was supplied. And the Census Act provided no indication that Congress intended municipal governments to act as monitors of the Census Bureau that verify the accuracy of census data releases. And this case highlights that Title 13 is intended to safeguard the integrity of the census and the trust of respondents, permitting data use only for the specific purposes for which it was collected, not for any potential statistical use. And as this history shows, statistical confidentiality protections have evolved over time in response to real-world challenges. This evolution is reflected in a wide body of principles, ethical codes, policies, statutory mandates have been developed and refined over time. And statistical confidentiality rules have not only shaped the practice of statistical agencies, but their influence has expanded into other areas such as consumer privacy and data protection. For example, the GDPR provides that further processing of data for statistical purposes is generally considered compatible with the original purpose, provided appropriate safeguards are in place, and similar exemptions appear in the California Consumer Privacy Act and Canada's proposed Consumer Privacy Protection Act, among other frameworks. And it's important to note that statistical purpose exceptions are central to balancing two competing goals, providing access to data for analysis while protecting confidentiality and privacy. And this balancing act appears across many regulatory frameworks. But when statistical purpose limitation was adopted in the consumer privacy domain, much of the critical context about how statistical purposes could unlock new potential while constraining risk to individuals was lost. For instance, under the GDPR, further processing for statistical purposes is generally presumed compatible with the original purpose. Such processing is considered lawful. Personal data can be retained longer for statistical purposes, provided appropriate safeguards are in place. And the scope of the statistical purpose definition under the GDPR is very broad. It's defined as any processing necessary for the production of statistical results, which scholars have argued likely includes commercial analyses and machine learning. And because recital 162 treats the outputs of statistical processing as non-personal data, much of the resulting information falls outside of the scope of data protection rules altogether. It's also notable that the enabling and constraining roles of statistical purpose in the official statistics context seem unbalanced when carried over into this new context. Under the GDPR, the statistical purpose limitation is treated predominantly as an enabler of data access without the historical statistical confidentiality safeguards that constrain use and disclosure to protect individuals. And a central problem here is that despite its role in defining the boundaries of permissible data use, the term statistical purpose is often left underspecified or undefined altogether. This has given rise to a large number of interpretations, which are often conflicting. However, this phenomenon does not seem to be well understood, as regulators and regulated entities frequently act as if statistical purpose has a single commonly accepted meaning. And historical challenges within official statistics suggest that interpretations of statistical purpose are often contested, and this is a problem that's likely to grow in frequency and significance as demand for statistical and machine learning analyses continues to grow. So I'll turn now to a brief overview of the many potentially conflicting interpretations of statistical purpose and their underlying assumptions and limitations. I argue that statistical purpose is a multidimensional concept that's shaped by many interacting elements, each of which is interpreted in different ways. While statutory language often leaves terms incompletely specified, the meaning of statistical purpose stands out as especially indeterminate. And to make sense of this, we can use a typology that breaks down the various elements that contribute to how statistical purpose is understood in current regulatory frameworks. And what we find is that even within the same category, interpretations can vary widely, and this reflects ongoing uncertainty, especially around how to process personal data for statistical purposes without revealing information about individual subjects or potentially leading to harm. So this typology identifies 8 elements of statistical purpose definitions. The first is common to many notions of statistical purpose. It's the statistical production element. Statistical purpose is fundamentally concerned with the development and production of statistical results. And here production carries the meaning that it has in the EU Regulation 223/2009 on European statistics. It's generally understood to include all activities necessary to compile statistics from collection and storage to processing and analysis. And similar language appears in Convention 108 and Recital 162 of the GDPR, which describes statistical purpose as any operation, collection, and processing necessary for surveys or producing statistical results. And the second element is population analysis. This emphasizes that data are processed to characterize groups rather than individuals. So some regulators have explained that while statistical activity uses information about individuals, the goal of statistical purpose is to describe the population as a whole. And this means processing for statistical purposes uses information from many people to elaborate results that characterize collective phenomena. And this principle appears in US law as well, such as in CIPSEA and the Federal Statistical Confidentiality Order from OMB, which defines statistical purpose in terms of describing, estimating, or analyzing groups without identifying any individuals or organizations that comprise them. And this leads into the third element, which is non-identification. This element emphasizes that statistical processing and its output should not identify individuals. Interpreting this is complicated because the term non-identifying itself lacks a single consistently understood definition. But if we set that question aside for the moment, we can examine how it's used in laws like CIPSEA, which defines statistical purpose in terms of non-identifying uses of data. In other words, analyzing groups without identifying the individuals or organizations that comprise them. And another example is the GDPR, which focuses on non-identifying results rather than non-identifying uses, and explicitly treats the results of statistical processing as non-personal data, meaning the outputs do not contain information relating to any identified or identifiable individual. And the fourth element is aggregation. This is an interesting compound element. It's multiple overlapping meanings that tie together the first three elements. Aggregation is often related to the goal of statistical production. For example, some definitions define statistical purpose as the elaboration of statistical surveys or the production of statistical aggregated results. Another interpretation is related to the analysis of collective phenomena. For example, definitions may describe statistics as aggregated and representative information characterizing a collective phenomenon in a considered population. And aggregation is also related to non-identification. For example, as I mentioned, Recital 162, the GDPR emphasizes that results of statistical processing are not personal data, but aggregate data. It's important to recognize that aggregation alone is not a guarantee of privacy or confidentiality, because releasing aggregate statistics still carries risks to individual privacy. But this is a term that appears throughout many definitions of statistical purpose. And the next element is the non-administrative element. It emphasizes that a statistical purpose excludes administrative, regulatory, and law enforcement uses, as well as any other use that affects individual decisions. For example, CIPSEA distinguishes a statistical purpose from a non-statistical purpose, defining a non-statistical purpose as the use of data in identifiable form for any purpose that's not a statistical purpose, including any administrative, regulatory, law enforcement, adjudicatory, or other purpose that affects the rights, privileges, or benefits of a particular identifiable respondent. And the next element is the ancillary activities element. This captures aspects of statistical purpose that explicitly include other processing activities supporting statistical work. For example, CIPSEA defines statistical purpose to include the development, implementation, or maintenance of methods, technical or administrative procedures, or information resources that support such statistical purposes. And the next element is the prescribed purpose element. Comes from subsection 9A1 of Title 13. It restricts the Census Bureau's use to the statistical purposes for which the information was supplied. Where applicable, it specifies that the Bureau cannot use or share the individual level data for any other purpose, even other potential statistical uses beyond the purposes prescribed by statute. And the eighth element is harm prevention. derives from statistical confidentiality and ethics. It's reflected in, for example, subsection 8C of Title 13, which prohibits using census information to the detriment of any respondent or other person to whom such information relates. And this element is highly contested. As a prominent example, we can refer back to Raymond Okamuro's argument that providing census data to the War Department for Japanese internment was not for the purpose for which it was supplied, and was clearly to the detriment of the persons to whom such information related, while the former deputy director of the Census Bureau, Herman Haberman, maintained that Title 13 does not prohibit the use of aggregate statistical information, even if it may harm groups. The Census Bureau has no authority to make value judgments about how statistical data will be used. And this examination exposes deep disagreements about the meaning of statistical purpose and indicates that its boundaries are largely unsettled. So the next step, we can look to external authorities for guidance on interpreting the concept and identifying ways to approach some of this ambiguity. Federal statistical governance is shaped not only by statute, but also layers of long established and refined policies and standards. In the US, the Office of Management and Budget issues standards and policy directives that, together with laws such as CIPSEA, form a framework for governance of federal statistics. And consensus-based principles and implementation guidelines have also been produced by bodies such as the National Academy of Sciences and the United Nations. These authorities provide extensive detailed guidance on how statistical data can be governed through institutional policies, procedural safeguards, and enforceable confidentiality rules. And the role of these guidance documents is often overlooked when interpreting regulatory requirements, particularly in commercial contexts, but they're essential to understanding what effective statistical governance actually requires. Another source is professional codes of statistical ethics. A prominent example is the American Statistical Association's ethical guidelines for statistical practice, which apply broadly not only to official statistical agencies, but to all statistical practitioners across sectors. And as some examples, these guidelines require practitioners to respect the rights and welfare of human subjects, use data only as permitted by consent or where consent is not required, careful attention to individuals' interests, must limit data collection to what's necessary, minimize re-identification risks, be transparent about how de-identification affects accuracy. Guidelines also emphasize anticipating and addressing harms, particularly those to vulnerable populations, to assess societal and group impacts, recognize risks to marginalized communities and harms to public perception, avoiding statistical practices that exploit or perpetuate unfair outcomes. And the former deputy director of the Census Bureau, Herman Haberman, pointed out that those who direct statistical agencies must consider and prepare for how they'll react to different situations, including ethical challenges before they happen. And established codes of statistical ethics can serve as a guide for regulators and practitioners seeking to clarify and strengthen their policies and practices around processing for statistical purposes, while balancing data availability and data protection. Ethical guidelines for statistical practice can be particularly instructive when it comes to understanding controversies like the Census Bureau's special tabulations issued post 9/11. They compiled detailed information on how many people of Arab background lived in certain zip codes in the United States for the Department of Homeland Security. Although Customs and Border Protection contended the information would be used to help the agency identify which airports to post signs and pamphlets in Arabic, they raised questions about whether the information requested was necessary for the stated goal. If data minimization principles had applied and the Bureau had taken into account the risk of harm to a vulnerable population and the public perception associated with a special tabulation of this data, perhaps it would have supported a decision to provide less granular information or a refusal to prepare the special tabulation. Another source of guidance on these topics is the theoretical computer science literature on privacy in statistical analysis. We know from research in this area that even aggregate statistics or machine learning outputs can leak personal information, as shown by attacks like membership inference attacks, model inversion attacks, and database reconstruction. We know that traditional definitions of identifiability often fail to capture these risks. The definition of differential privacy, developed in 2006, provides a formal mathematical framework that allows the analysis of data at a population level while offering provable protection against a wide range of privacy attacks, including future unforeseen attacks. It's robust to auxiliary information, composition effects from cumulative uses and releases of data, and post-processing. And according to this framework, effective privacy-preserving computation must consider the analysis itself and the accumulation of leakage over multiple releases of information in order to ensure meaningful protection of individuals. And with the adoption of differential privacy in the disclosure avoidance system for the 2020 census, controversy arose when researchers observed that even when census data is processed using this methodology with differential privacy, researchers could still, with some accuracy, predict individuals' race from aggregate demographic statistics and election results, and applying insights from the theoretical computer science literature can help clarify why this happened. The use of formal privacy models limits the amount that any one individual contributes to the output, but it does not prevent inferences based on population level patterns. And you could argue that this is consistent with many of the elements of statistical purpose and support a finding that these are statistical inferences rather than privacy violations, because they're based solely on population level demographic information. And making explicit the different concepts embedded in statistical purpose provisions, and in particular clarifying the underlying privacy-related concepts and sharpening them based on insights from the computer science literature can help address potential tensions that arise in practice. And I'll conclude with a few ideas about how we can build practical interventions and what the implications are for practice. And so the 8 elements of statistical purpose show that the concept is inherently multidimensional, different definitions emphasizing different elements and interpretations of those elements. And this presents an opportunity to clarify interpretation by developing a comprehensive definition that makes explicit the multiple connotations that are reflected in existing definitions. It may be possible to define statistical purpose in a way that combines these different elements and emphasizing that statistical purpose means activities related to collecting, storing, processing, analyzing data to produce statistics that characterize collective phenomena. These activities exclude administrative, regulatory, law enforcement, or individual decision-making uses, must be carried out with safeguards to minimize risks of harm to individuals. May also include the development and maintenance of methods, procedures, or resources supporting such activities. And by combining the 8 elements and drawing on guidance from statistical policy, ethics, and theoretical computer science, this can clarify the meaning of statistical purpose. And considering and refining this definition in a policy-making context can help unify practices and provide foundation for more effective governance. And if we look to existing literatures related to statistical policy, ethics, and the computer science research on privacy, this can provide foundation for defining the core concepts and best practices with respect to statistical purpose. It can guide the design of systems that incorporate multiple layers of legal, technical, and organizational controls with the goal of ensuring more robust protection for data subjects, and greater certainty for practitioners. Some controls highlighted in the literature that could be layered in this way include anonymization, privacy-enhancing techniques to ensure functional separation, interactive mechanisms as part of a tiered access system, data minimization, particularly limiting data collection with respect to sensitive information and considering non-release or releases with less geographic detail and high-risk context, and commitments to and training in statistical ethics. And I'll conclude by saying statistical purpose plays a critical role in both constraining and enabling data processing activities in ways that contribute to achieving an appropriate balance between data access and data protection, but it remains underdeveloped. And this creates uncertainty for practitioners that process personal data for statistical purposes across a wide range of domains and could contribute to a suboptimal balancing of access and privacy. Existing resources from statistical policy ethics and computer science research may provide potential foundations for defining and guiding core concepts and practices with respect to statistical purpose provisions, and establishing clarifying definitions and producing guidance on applying these provisions and selecting reasonable legal, technical, and organizational controls will be critical to ensuring greater certainty and adequate protection for data subjects. Thank you.
Excellent. Thank you so much, Alexandra. And I'll invite all the presenters to come back on video. Just want to say, been looking forward to these set of presentations for a long time, and thank you so much for a really whopping set of presentations. I will go to the Q&A. We've got some questions lined up, but I wanted to quickly pause and see if any presenters had quick questions for each other. I will reserve that privilege in case anything comes up during the Q&A, but just wanted to pause for a second to see if there were any questions. If not, I'll go straight to the Q&A. So I think at the top of the queue here, we have a question from Omar. In what way the evolution of the term statistical purpose in the United States influenced the way it's interpreted and understood by the rest of the international statistical system? Thank you very much for this excellent and insightful presentation. I know, Alexandra, you had touched a bit on other frameworks, such as in Europe. Wanted to see if there was anything you wanted to add in response to Omar's question.
I think that the U.S. Census Bureau has served as a model for statistical agencies around the world, and its interpretation of statistical purpose and related concepts has had a very strong influence on other statistical agencies around the world.
I'll jump in really quick, JJ. It's interesting because when you look at like the ISI and other, just other European organizations, and they have principles and, practices sort of like the principles and practices that we have from the National Academy of Sciences, and they just use the term statistical purposes, and you dig and dig and dig and dig and dig, and it's not defined in some of the main documents. And then there are other agencies, I think it's maybe Australia, I could have this wrong, where the person who decides is the sort of chief statistician. So it lacks the clarity that Alexandra is talking about. It's used, and it may even have been used as long as we have used it, or just shortly after the Census Bureau, but it's just sort of thrown out there like everyone knows what it means.
Thank you. So the next question is from Isabella. Thank you for the amazing talks. You mentioned that the regulators often treat statistical purpose as a single settled meaning when it is actually quite contested. How does this lack of clarity impact long-term survey participation and public trust?
Actually, if I could start with that one, although I'm eager to hear what Alexandra has to say on this one too. I think at the crux of that question, I think is one of the challenges for the term itself, and that's the term is used with different audiences in mind, and it's used for different things. So regulators might use it, or like legislators might use it in an attempt to prescribe what can and can't be done with the data for the agencies to know, or in the context of private sector data for the enterprises to know. But we also use it for other things. And so we also need to be able to explain to data subjects what we're doing with their data. So I showed at the beginning of my presentation respondent communications, where we're saying your data will only be used for statistical purposes. And then it's also used to kind of inform on a day-to-day basis, like what agency employees should or should not be doing with the data. And so the type of clarity that you're going to need in a statutory or regulatory context differs from the type of clarity you're going to need when communicating to respondents, and the type of kind of guidance that you're going to need or interpretation that you're going to need to inform an employee's like day-to-day understanding of what is or is not an acceptable or an appropriate use of the data. And so we're using one phrase kind of in all of these contexts. And I think that's part of what the source of the ambiguity is because you don't want it to be too complex if you're going to be communicating to a data subject, because you have limited real estate to communicate it, and B, you need to make sure that it's understandable, which I think our current phrase is certainly short, but our own research shows that it's not understandable, it's not interpretable the way we intend it to be sometimes. But you need it to be sufficiently detailed in the legal and kind of implementation context so that people know or can determine what strictly is or is not permitted. And so you're going to need different levels of clarity when speaking to those different audiences.
I think that's right. And I think that statistical purpose is a useful shorthand. And because it's embedded in such a rich history, I think it's well supported in many respects as a strong set of confidentiality protections. But I think that some of these cases illustrate ways in which public trust can be undermined if statistical purpose is not well defined. I think an example is this post 9/11 special tabulation of data for the Department of Homeland Security. So the Census Bureau said, this is data that's to be used for statistical purposes. And CBP said the same. But if the public doesn't trust that that's accurate and enforceable, then that erodes some of the trust in statistical governance. And I think that there are similar issues when statistical purpose is carried over into consumer privacy and data protection contexts, where a commercial entity may say that it's using data for statistical purposes and therefore it doesn't need to obtain new consent from data subjects. This may raise questions about whether that organization is adhering to the body of statistical practice and confidentiality that's implied by the term statistical purpose. And that can create trust challenges for those organizations.
If I could add one more thing to that, spot on with a lot of what you were saying, Alexander, but I think this also kind of highlights one of the major challenges that we have with kind of informed consent more broadly, and that's the oftentimes people are signing or agreeing to privacy statements, privacy policies, without understanding what those policies or statements are actually saying, and efforts to be more specific and be clearer don't always have the intended consequences. I know the Census Bureau ran some cognitive studies a few years ago where trying to improve the understanding or respondent understanding of the confidentiality protections that were afforded to census data had the perverse impact of reducing people's propensity to participate, because it put the dangers, like the potential harm, from all the discussion of confidentiality, put that front and center in people's minds. And so trying to reassure people of confidentiality could actually kind of undermine what you're trying to get them to do in the first place. And so you run this challenge of kind of structuring these kinds of notices in a way that people truly understand, without overwhelming them with page after page after page of information on the one hand, and without kind of scaring them off on the other.
So we've got a fairly meaty question here from Tom. I'll try condense it. So Tom's question is regarding the ASA's ethical guidelines for statistical practice, and a particular version of it that had a sentence in the preamble: above all, professionalism in statistical practice presumes the goal of advancing knowledge while avoiding harm. Using statistics in pursuit of unethical ends is inherently unethical. So he points to the fact that the sentence was removed in the approved 2022 guidelines, where the only use of the term harm is in the guideline in the section on integrity of data and methods that states the ethical statistical practitioner exercises due caution to protect proprietary and confidential data, including all the data that might inappropriately harm data subjects. So the question that Tom's posing here is, do any of the speakers know what motivated the change, and do you think the current language suffices?
So Tom and I, as he mentioned in his question, Tom and I overlapped on the ASA Ethics Committee several years back. Unfortunately, by 2022, I had rotated off of the committee, and so I do not, off the top of my head, know what had prompted the change. Although I know a lot of thought went into that round of revisions. So I unfortunately cannot speak to why the change was made, and I'd want to look more into the context around the passage that you cited, Tom, to see if what my thoughts are on whether it's addressing everything that the original wording did. So I'm gonna say I'll get back to you on that.
Thanks, Michael. So another question for our Census Bureau colleagues: how do you approach requests for access to confidential data for research studies by external researchers or researchers at other government agencies in the context of your interpretation of statistical purpose? Question mark.
I'm happy to jump in here. So, whether you're an internal census researcher or an external researcher that's coming into and using data through FSRDCs, or a researcher at another agency that might also be coming in to use our data through through a federally research data, Federal Statistics Research Data Center. There's a process. There needs to be a proposal. There needs to be an explicit description of what we call the Title 13 benefit, or if you're using IRS data, it's the Title 26 benefit that this research will provide. In other words, we don't allow just any research to take place with our data assets. And then, of course, you have to become special sworn, like we all are at the Bureau, which makes you beholden for your entire life to keep these data confidential. And then everything that you do with the data, and if you are mid-course in your research and you want to take a deviation of what you're doing, and you say that it's aligned with the Title 13 purpose and it's involving data from Agency X or one of our programs, you have to review the data use agreement to ensure that it's in alignment with what is allowed with the data. How can you actually use these data? And then, of course, before any of the results are going to be released publicly, it goes through the disclosure review process, of the Census Bureau, which is quite rigorous. We may share internal results that under Title 13 protections of looking at them together internally, that haven't formally gone through the disclosure review. But it is really important that there's a process, and there has to be a reason for doing this that adheres to our title or other titles. So for example, let's say some agency wanted to come in and just kind of look around to see what data we have. That's not going to happen. They won't gain access.
Thank you. And a question from Omar here. How do you foresee the evolution of the statistical purpose in light of the development of big data and increased digitalization?
So I'll step in on that one. I think that's a great question. I think kind of central to that is the confidentiality piece, and that's we have an obligation when we are publishing statistics and statistical products to ensure that respondent information is sufficiently safeguarded, and that you can't kind of pick out specific individuals with reliable certainty in those products, or to learn things about them from the fact that they had participated. And so as big data increases, as computing power increases, as optimization algorithms improve in their power, re-identification and privacy attacks on quote unquote de-identified data are getting to be more and more of a concern. And so I think as we see this trend continue, our job as kind of the stewards of these data gets harder and harder, because we have to make sure that we're continuing to keep pace with these new privacy attacks in order to make sure that the data that we do release remains properly safeguarded. And so I think that's going to be the big challenge there. And it's not just, as Sally was mentioning, it's not just kind of the statistics that we are directly producing ourselves and the statistical products that we are directly releasing ourselves. It's also making sure when we have external researchers coming in through the Federal Statistical Research Data Centers, or when we have people using kind of tiered access mechanisms that some agencies have, that those uses are also being properly safeguarded, such that everything that's kind of like leaving the firewall, whether a direct product from us or a secondary product that we are supporting through the FSRDCs, et cetera, is not contributing to kind of the re-identification or kind of confidentiality violating inference that would undermine that statistical purposes pledge.
And it's interesting to note that anything that comes into the Bureau falls under, how we will treat it is it falls under Title 13 protection. Even if another agency protects it in a different way or has, less protection on it, as soon as it comes into us, that set of data for us is protected under Title 13. And what we do with it is governed by Title 13. And so if you think about that, pull that thread a little bit, the Census Bureau collects a lot of data for other agencies. Our data collection comes into the Census Bureau. It's protected under Title 13. And so it's really kind of an interesting dance then of what goes back to those agencies to help support the reason that they collected that data. It's not the microdata that we're protecting. So that's where it's really important. And even if the data is available, at some external website and publicly, we take a lot of scrutiny and we have to go through a lot of effort if we're to use it without the Title 13 protections. And there is a process for that. There are a few things that are easily scraped from governments on websites that we use in different ways. And so that's so it's interesting. And and I learned this little fact way early in my career, and I just couldn't understand. You mean they're paying the Census Bureau to collect this data and they don't get their data back? And the fact of the matter is that they don't necessarily get the raw microdata back.
Thank you. The next question we have here is from Ed. I would be interested in what Dr. Wood and others might suggest to determine whether ACS data that is probably being used by DHS contractor Palantir for its elite software enhanced lead identification and targeting for enforcement is actually being used potentially as a part of AI agent training data sets, and if such use can be constrained by reference to Title 13 use on harm. Can the end user DHS be constrained, or the data user Palantir be constrained, or both?
They are most certainly not using the confidential data from the ACS surveys. The only thing that they have access to is the same thing that everyone else has access to. The tabulations from the ACS and the PUMs from the ACS.
And I'll add on to that. When we think about the vulnerabilities of data, when we think about re-identification risk of the products that we publish, we often think about what other data are out there in the wild held by any number of different types of actors, whether those are private sector entities, whether they're foreign governments, whether they're state or local governments, whether they're federal agencies. Lots of data is held by all of these different groups that could be leveraged in one way or another to try to re-identify individuals in the products that we're releasing. And so we think about all of those different types of vectors of attack that could leverage one or more of those other kind of external sources of information. And we have to be aware of where those vulnerability points are and adjust our statistical disclosure limitation techniques accordingly.
And I just want to say one other point that really relates to things that Alexandra and Michael said earlier, is that when it comes to really trying to help people understand statistical purposes, I think that, perhaps we should be spending, a significant amount of effort on local, state, and federal government officials to understand what that means. Because the example of Palantir and information that flows into it, a local government may not quite understand the implications of releasing their wastewater data, the data from their wastewater data collection. It tells phenomenal amount of information about the individual to the location, but they may not even be thinking about such a thing, that this would be particularly harmful. And sure, I want to participate in a program. And I'm not saying this is happening. I'm just using it as an example that I had a recent discussion with a colleague about. So I think that there is some work to be done to help local, state, and federal leaders understand what this means, so that they really understand where, the constraints are of what they could possibly envision, doing with certain types of data, and not just ours, other sources that should be paying attention to in terms of what's getting released.
I would add the general public to that as well. Some of
absolutely, absolutely, Michael, but I think that yes, the general public for sure, but with special attention on these local leaders. The general public is going to be an even bigger challenge.
The example that comes to mind for me with that is when we were doing our census barriers and attitudes survey on barriers and attitudes, CBAMs, barriers and attitudes motivators study. That was it. In the run up to 2020, and some of the related research that was going on there, we were asking individuals about their attitudes about privacy and confidentiality, and there were questions about re-identification risk. And what was interesting was when you talk to kind of your average data subject about the risks of re-identification of their data, they immediately think about hacking. And so there's not this general awareness that even kind of seemingly unidentifiable information could be leveraged to pick you out again in these other sources. And so I think as a society we need to be better informed and educated about the kind of the sources of privacy risk that confront the data that we kind of let out into the wild.
Thank you. Rochelle asks, commenting on the 9/11 example, the Census Bureau decided to make public its decision and actions, which is how it can be used as an example today. This explicit transparency was intended to serve as a safeguard in and of itself, knowing that the decision would likely face differing perspectives. I'm sure the speakers all value transparency and would perhaps like to speak to how it fits into applying statistical use only.
So Shelley and I are on board with the idea of radical transparency in the statistical process from our time when we worked with the Commission on Evidence-Based Policymaking. I think transparency is one of the fundamental like privacy principles, the Fair Information Practice Principles, the FIPS, and I think how individuals' data are being used it's important to be fully transparent to the extent you can about what you are doing with those data and how the decisions are being made about what you are or are not doing with those data. And so I think respect for the individual, respect for the person who's providing that data to us either directly or indirectly, and we as stewards of that information have an obligation to them to be transparent about that decision making. And so I think the being public about the Arab American tabulations after 9/11, I think is part of that responsibility as responsible data stewards of the public's information. If we want to keep their trust, we have to be upfront about what we're doing with the data.
And this is amplified anew in the gold standard science executive order, as interesting as that is.
Awesome, thanks. Just keeping an eye on time, I think we have time for one more question. There's two more in the queue. Let's see if we can get through this. Khalil asks, given increasing demand for granular data, expanded data collection by public and private entities, and more sophisticated data linkage techniques, how can we release meaningful, high-quality statistical data while protecting confidentiality?
I think we should lob that one to Alexandra and her topology.
I think we can look to privacy research findings that point to the privacy utility trade-off and approaches that can strike the most optimal point on that privacy utility curve. And so I think formal privacy models are the best tools we have available today for balancing privacy and utility and gaining the most utility you can from the data while protecting privacy. And I think many of the examples that we've been talking about with the last few questions about the rise of big data, machine learning, greater uses, releases of data, and the greater availability of auxiliary data for carrying out an attack really forces us to contend with this privacy utility trade-off and to try to find approaches that can maximize utility while protecting privacy. And I think that the privacy research provides that toolkit, and I think more work is needed, both to develop those technical approaches, but also to understand their relationship to legal and policy considerations in this area.
I would ditto everything that Alexandra said and add it's also critical to understand where the vulnerabilities are and not just have strong research and development into disclosure limitation techniques, but also have sustained research into kind of where are the privacy vulnerabilities, like what are the vectors of attack, because you can't protect something if you don't know where it's vulnerable. So that's what I would kind of add on to that.
Awesome, thanks. I'm going to try sneak in one more question here real quick in the 1 minute that we've got. And from one more question from Ed is, would confidentiality protections afforded to individuals apply to misuse of ACS data for identifying specific households, i.e. where the specific person in a household who is a non-citizen is not identified, but where ACS data reports proportions of households in a census tract that have non-citizens in them?
Yes.
Well, Title 13 protections apply to people who are accessing the confidential data. It prohibits us from disclosing the information or using it for an unauthorized purpose. Title 13 protections don't have any application on like the data once it's already been released. So yeah, like the $250,000 fine and the 5 years in jail is if we do something we're not supposed to with the data, it doesn't apply if somebody takes what we have published in the public domain and uses it for some nefarious purpose. It doesn't extend that far.
And I expect that the confidentiality protections that we're putting on the ACS would not let this kind of analysis to actually move forward in any way that would have validity.
Great. And with that, unfortunately, we are at time. I'm going to share a quick slide here, highlighting some of the events that are coming up that SOTA are putting on in the next couple of weeks. I want to thank everyone for joining us today. We had some really great turnout. And of course, I wanted to thank the hosts and really thank the presenters for putting on a really, really great and informative webinar. So thank you very much. I appreciate it. Oh, and one last quick thing is the recording for this webinar will be made available on the SOTA website next week. Thank you.
Thank you, everybody.
Happy
Thank you,
Privacy Day.
June.
Happy Privacy Day.